Welcome to this webinar. This is a webinar which was originally aimed at IBM licensees based in the United Kingdom and Ireland, and indeed the European Union. That webinar went down very well, and I've been asked again to do it for the US market. However, because of this, that it was for the UK-Irish market, some of the content will be less relevant to US listeners, but I hope anyway you take considerable value from it.
In this webinar, we're going to sort of start from the beginning, always a good place to start. We'll build up, so if some of it seems to you like fifth form school, please bear with me, we will pick up. But I often find, particularly in the software and the software audit market, that many people have a slightly shaky understanding of what is intellectual property, particularly to software, what is a license. So we're going to pick that up. We're going to look at some surprising answers to some questions. Look at SAP, which a lot of people have asked me about. Third-party where they went wrong, and patches, fixes, and upgrades, which is often a frequent question. So without further ado, this is entry-level stuff. So those who know this, go for a coffee. I'll be about 2 minutes on this. Intellectual property is often the most misused phrase in the Western world. People say, we've got a lot of intellectual property. And I say, well, what is it? And they say, well, we've got programs, we've got these technical ideas. And I say, no, what you've got is you've created a lot of useful technology, but you actually often don't have much intellectual property protection for that. So what is intellectual property? It's where a country, by its laws, gives a legal monopoly for a fixed period for creation of the mind. The only time it's not a fixed period, by the way, is for trademarks. Trademarks can last forever, provided you're using them. But some of these legal monopolies will be 70 years after death, and software is protected by copyright, as you can see. And copyright, certainly in Europe, now lasts for 70 years after death, which is an immensely long time if you think about it. It's treated as a literary work in the same sense of a book is protected by copyright. Software is treated effectively as if it were a book, but instead of lines that you read in a plot and a narrative, it's lines of code. And that has certain consequences as to how it's protected. We talk about an absolute or qualified monopoly. A patent is an absolute monopoly. It doesn't matter if you came up with the idea yourself. If somebody's got a patent for that idea, they can stop you from using it. It must obviously be a technical idea. Copyright is different. It's a right against copying. If I just happen with a bunch of monkeys to come up with exactly the same software as what somebody else has written, I'm entitled to use that software. It's what we call a qualified monopoly. So copyright and software. Well, I've given you a list. Any type of software, machine code, firmware, middleware, fixes, patches, scripts, routines, it's all protected. It's protected automatically. The moment you write it, it's protected. And it belongs to the writer of the program as a first base rule. But if employed, then owned by his or her employer, and it can be assigned. Many people ask me about, well, commission software. Commission software would generally belong to the commissioner, the person who commissions it, provided it's for money or money's worth. And when I say these things, I'm tending to have a sort of common law EU focus to what I say. Obviously, I can't speak for every country's law, but so forgive me if I have a little bit of a focus on what I would describe as common law jurisdictions, but I will also be looking at EU law as well. So copyright for software arises automatically Anybody who copies a script routine that somebody else has written will be an infringement of copyright if they have no permission or consent. So let's look at what is an infringement. Again, there's quite a lot of misunderstanding here. Permanent or temporary reproduction of a computer program by any means, in any form, in part or in whole. Alteration or adaptation. So for instance, compilation from source code to object code, that very act in itself is an act of infringement. Distribution to the public of copies of programs, that is also an infringement. If somebody gives a copy to you, you haven't actually copied it yourself, but that copy was unlicensed, and you distribute that copy to the public, you rent it, you put it online, you make it available. All of those acts are infringement. I focused on EU law, but to be honest, most of this is true in any country throughout the world. Perhaps the most important act of infringement is the moment you load up a computer program. That is an act of reproduction. If you load it up into RAM, random access memory, that involves a temporary reproduction of that program in part or in whole, and that is an act, therefore, that you will need to have the permission of the copyright owner to do. So a lot of people think, well, I'm just running the program. I didn't copy it. I didn't put it onto a DVD. I didn't put it onto the web. Surely that's not an infringement. The answer is, yes, it is an infringement. You do need the permission of the copyright owner. So a lot of people say, oh, we have a license. And I just thought it's worth repeating here. What exactly is a license? A license is basically the right to do something that would otherwise be an infringement. And that's quite important to remember. A license basically lifts the legal monopoly from the acts that you are doing. So if an act is an infringement, if loading and running a computer program is an infringement, if a copyright owner gives you permission to do that, that is a license. You can call it permission, you can call it consent, call it whatever you want to say, but it is effectively stopping them from suing you for infringement. So another way to do it is to say a license prevents the copyright owner from suing you for infringement. And of course, you can give a license for a period of time, for certain acts. It can be sliced and diced in any way you wish to do so. But the whole thrust of a license is, I'm giving you permission to do something which otherwise I would be able to sue you for. But in licenses, you may have a license which is 40 pages long, and it may have things like audit requirements. It may have payment requirements. And there's a lot of confusion I find in the marketplace as to what are the consequences of breach. For instance, you may have in the license that certain employees need to be vetted. Certainly my experience is that agreements get longer and longer every day, and you need to understand the structure of a license. So what I've done is put a sort of image here which tries and breaks up licenses effectively into three parts. The green is where the act that you're doing isn't a breach of any term and condition. The yellow is where you do breach the license terms and conditions, but it in itself is not an act of infringement. So for instance, let's say that you do not pay or you're late in payment. Does that mean you're infringing? Or you don't effectively, you breach an audit provision? Until that license is terminated for breach, and they may not be able to terminate for breach. Often licenses will have clauses like, if it's capable of remedy, notice to remedy and you don't remedy within 30 days. So they will have to give you the right to remedy. But non-payment, breach of audit provisions, is not in itself an infringement. It's just simply a breach of contract. And this concept is very important. Breaching an agreement may give rise to just a straightforward breach of contract. So if you don't pay, the remedy is that effectively they get an order that you do pay. If you don't allow an audit, or in some way, if they don't seek to terminate the agreement, then the remedy is to order you to allow that audit or damages for not auditing. But there are obviously acts which not only are a breach of contract, but are also an infringement. As we say, the acts lie without the license. That is, for instance, having too many installed copies, because as we've discussed before, every unlicensed copy is an infringing copy. So it's important to keep that in mind. Don't think, oh, we breached the terms and conditions, therefore we're infringing, therefore they can sue us for copyright infringement. That doesn't follow. You need to be very aware as to whether the breaching act itself is an act of infringement. But in most countries as well, we have an overlay of law on terms and conditions. So one which a lot of people aren't aware of is that in European Union law, a licensee cannot be prevented from carrying out acts where they are necessary for the use of the computer program by the lawful acquirer in accordance with its intended purpose, including for error correction. And importantly, that cannot be contracted out. That's the software directive in the European Union. US law is less generous in this respect, but I just want to sort of just explore that, if I may, a little bit. I've highlighted error correction. Let us say that you are given a program, and the program you have bought, you have a license for it, but it is extremely buggy. It's got a lot of problems which are stopping it from working in accordance with the intended purpose. And the problem is that it's come to end of life. So the software vendor is not providing any further patches, fixes, or anything like that at all. And yet the program isn't working. It's simply not doing what it's meant to do. In those circumstances, in EU law, if you can say that amounts to error correction, and although there's not been tested in the courts, error correction seems to me to be anything which stops a program from working in accordance with its intended purpose, then effectively you can do any act and it will not be an act of infringement. And that's an important point to bear in mind. For instance, you may feel the need to modify the software, which would in itself be an act of infringement. But under EU law, if that modification is done to fix an error, it wouldn't be an act of infringement. So you have on top of the license a sort of statutory framework, a legal framework, which regulates the enforceability of infringement actions and also regulates how licenses work. So a little bit on to IBM. IBM is a software vendor, we all know it. What my experience, and it's not just IBM, it's with many big software vendors, is that their licenses are not models of plain English. In fact, it's often extremely difficult to work out precisely what are the licensing terms and conditions. And remember, the license determines whether the acts that you do are acts of infringement. So with IBM, you start with the IPLA. Here I'm looking at the base license. The IPLA is a perpetual license. You buy it, and it gives you the right to use the software forever, which of course was very much the old style of licensing before we moved on to cloud-based subscriptions. And the IPLA is a reasonably understandable document, but it has, in my view, certain wording issues. Then the IPLA is essentially the same for any product, IBM product. Then you have what's called the LI, the license information. And this will basically relate to the product, to the software product, and will tell you effectively how the license works for that product. And we'll have a look at that a little bit more. Then you have the proof of entitlement, passport advantage. The proof of entitlement will tell you, for instance, what metric is being used for that particular software product. Often because your first year of support, and this may be going back many, many years, comes for free, it's sort of contained with or included with the passport advantage agreement. But the proof of entitlement relates to license. Passport advantage is primarily related to software and support. So a license can basically say, I hereby grant you a license. This is the fee that you will pay. And obviously, if you don't pay that fee, then that in itself is a breach of contract. But generally speaking, of course, they can terminate the contract if you fail to pay. And most of you will know the different licensing metrics used. I've just been focusing on some. Full capacity, all activated processor cores in a hardware environment made available to middleware. IBM introduced this in 2006. We're going to come on to a very interesting set of questions, but just bear that in mind. Subcapacity, maximum number of virtual CPUs made available. And again, you'll find in IBM it's all about made available, not necessarily used. Some more old-style metrics, number of users, level of usage, and indeed in the very old days, it was just number of installed copies, or blend of above. The licensor, the software vendor, is perfectly entitled to choose any of those metrics, provided, and there is a little bit of proviso, it's not anti-competitive. So a metric which might be anti-competitive is where you're required to use other software from the licensor if that's what we call an illegal tie-in. But that's a very different discussion, and I'm not going to talk about competition law. So let's have a look at, this is from the IBM website, how that might work, and most of you will be familiar with this. This is a full capacity license. There's no virtualization. Full capacity license is counted as the highest number of PVUs on the server where the software is installed. And effectively, you then do the figures, 16, 70 PVUs per core, software cost per PVU, and then it's 16 times 70. These are going to be very familiar to many of you. But let's look at something that what happens when you move from a standalone server. In this case, this is actually from a case I was involved in. It didn't go to court, but there was a real issue. So what happened is the customer had IBM software installed, standalone server in the office. Consultant came along, advised moving to the cloud, but critically important, no study of the effect on license fees. Client moved software from standalone server to a cloud DLPAR, dynamic logic partitioning. Many of you will be familiar with how DLPAR works, but it effectively allows for dynamic partitioning of CPUs. Suddenly, the client found himself facing an enormous licensing cost increase because, of course, under the licensing metrics for virtual machines, effectively, it's how many vCPUs are maximum made available to the software. So suddenly the customer found itself having to potentially acquire a very large number of PVU licenses because under the dynamic partitioning, a huge amount of vCPUs were being made available. Client had absolutely no idea that this was going to happen. And in the end, actually, the cost forced the client to move back to standalone. Some attempt was made to do some partitioning, but it didn't really work.
So, Guy, this really is a great example of read your license agreements before actually switching. Is that correct?
Yeah, thanks for that, Sinead. It's one of the things I said in this case was, did anybody explain to you the difference of metrics for virtual machine over effectively standalone? They said no, they didn't do it. But of course, if they had read that, they would have known this and would never have moved to the cloud. It also raises an interesting point, which I'm going to discuss a bit later, is because this move was only for 2 weeks before he suddenly realized just how problematic it was. Are you required to pay a year's worth of license fees? Effectively. Now, we know that with IBM, they use usage, but of course, it's based upon a meter. And if you don't have the meter for that usage, then that could cause them to charge the maximum. And we'll look at that because it raises some interesting legal questions there. But Sinead's point is read the license that you have, and read the license if you're moving your environment that will apply. And remember, you are licensed to use it. It's just a different metric. The IPLA, remember, is a perpetual license. It's not a license, it's a license to use the software forever. The question now is, what is the charge? And that comes from the license information. So I'm going to look at 6 questions, which some of them I'm being asked and some of them I'm effectively asking myself. But these do pop up from time to time. Because if one strips away a lot of the discussion, the fog, the mist, fundamentally, we are just talking about law. We're talking about the law of contract, the law of copyright to software, and indeed the laws of various countries, particularly on competition. So let us say that you bought some software 1996. The environment in 1996 was very different. It was probably a standalone server, maybe one installed copy. You paid the price that you did, and you understood that gave you the right to use it for your business. Fast forward to 2020, and suddenly you find yourself with a very different set of metrics which applied to in 1996. Well, how does that legally happen? If I buy a car and pay, if I buy a car and pay, for instance, £4,000, I have the right to use that car forever. It would be a bit odd in 2020 if suddenly I'm being charged to use that car based upon my mileage and petrol. I say, I bought the car, I paid X amount of euros for it. Why am I suddenly now being charged by the car manufacturer on the basis of mileage? But in a way, that's what's been happening in the software world. So when people say, can IBM change or can anybody change the terms of the license unilaterally? The answer is very simply no. So then you ask me, well, how have these licenses changed? Generally, because when you renew your passport advantage, it takes priority over the IPLA. And I'll give you the clause for that. So when you upgrade, or if you upgrade your software, that will normally require you to accept the latest terms and conditions. Terms and conditions of license information change enormously over time. We'll have a look at one of those soon. So actually, that's the mechanism, the legal mechanism. You either renew your passport advantage agreement or you upgrade. You do some act which will require you to click on or sign that you accept that effectively the new licensing metrics will change. 2, can IBM or anybody recover punitive damages for unlicensed use? Generally, in most countries, punitive damages are not available. This is a little bit different in relation to civil law countries, but generally in common law countries, unless there's been intentional or fraudulent conduct, effectively, if you haven't paid, if you've been unlicensed in your use, you would pay what would be called the going rate for that. Are liquidated damages penalty clauses for breach? Let's say, for instance, you had an unlicensed period, you didn't realize. They say, well, I'm very afraid you've got to pay 3 times license fees because it's been for an unlicensed use. Generally, again, in English or common law jurisdictions, the answer to that is no. I've given you a British case. Now, I'm conscious that a lot of people here will not be UK based. Irish law tends to be fairly similar. Civil law countries, a little bit more generous to liquidated damages, but if they are manifestly excessive, they can be struck down. So don't think that just because you see a liquidated damages clause, which appears to be manifestly excessive, that you're obliged to pay it just simply because you signed, you didn't push back on that. There is a regulation there of the contract. What law applies to the interpretation of IPLA? Well, generally speaking, under the IPLA, it's where the licensee is established. And you see the clause that I give you. That's quite important because, for instance, as we've seen already with the EU software directive, if the EU law applies, that does limit the rights of software vendors in some critical aspects. And we've looked at error correction.
Here's a question, Guy, actually. So for large organizations who have the licenses and move the licenses around according to needs in other countries, what happens there?
Good question. Again, generally speaking, that will be still licensed. But what you may be doing unwittingly is moving yourself into a less generous jurisdiction. And by that, I mean, for instance, EU law tends to be more generous to the licensee than US law, which might be said to be a little bit red in tooth and claw. For instance, ask any Nebraska farmer trying to repair their tractors, which now have software in them, how difficult that is. And that, by the way, is at the moment subject to a lot of lobbying going on both sides of the fence. So if the licensee suddenly re-establish themselves in another country, it may be that in relation to that they're moving into a less generous jurisdiction. So actually, Sinead's point raises an interesting thing, and I find this time and time again. The lack of sort of really true awareness, and I mean deep awareness, of the licensing framework. Part of that is because these contracts are very, very hard to read, understand, and digest. But it can be done. I've had to do it quite a few times. To truly understand the licensing framework for any form of software, whether it's IBM or not, should be as important as any other part of risk management in a company. And I'm always surprised how it isn't really at the top, because there are a lot of minefields and tripwires there. But good question. So one of the questions often I find is, well, I've only done it for 1 week. And then does that mean I've got to pay based upon the minimum period that the software vendor would license? For instance, let's say the software vendor says, we only grant 1 year, 2 year free licenses, and the unlicensed use is for 1 week before you realized. Does that mean you have to pay a 1 year license, or can you pay effectively 1/52 of that? Well, generally speaking, damages for unlicensed use is based upon a notional license between willing licensor and willing licensee. It's what's often called the user principle. A willing licensor and a willing licensee doesn't mean effectively an unwilling licensor. So for the licensor to say the minimum that we grant is 1 year doesn't work in that, because effectively, if I came to a licensor and said, I would like to use your software for 1 week, and they would say, well, we're very happy to grant you for a week. My next question would be, obviously, I'm going to pay less than if I use it for 1 year. Of course, you're going to pay much less. That's this concept of willing licensor and willing licensee. And generally, obviously, 1 week's use does not equal 1 year's use. And most licensing on a willing basis would take into account the period of use that you intend to use that software for.
So for the big software vendors, and it was found there was a set amount of time that was unused, and they had the minimum requirement of the 52 weeks or the year, how much of a negotiation is it? Is it an easy one to bring on, or is it dependent on how much estate and how much that vendor might lose as a relationship?
Yes, good question again. I find in negotiation it's incredibly important to understand effectively what will happen if you don't reach an agreement. And to be able to do that, you have to know the law, the applicable law, and what is the effect. So, for instance, in some discussions I've had, not with IBM, but with another software vendor, in without prejudice discussions, so obviously I can't name any names or anything like that. But, it's a powerful argument to say, we all know in this room that it's a winning licensor, winning licensee approach to damages. And remember, this is all about damages for infringing use. Certainly in many countries, this user principle approach to the determination of damages is the approach taken. So if you can say to them, are you seriously telling me that if I came to you and asked for 1 week's license, you would say it would cost the same as 52 weeks? And if they say, yes, we would say, well, we don't believe you. We don't believe you. If you got the chance of making 10 million as opposed to 20 million, you're going to go for it. Why wouldn't you? And so because licenses generally cost, and indeed IBM, of course, recently introduced, I think it was in September last year, a sort of per hour usage metric, particularly in a virtual environment. People do understand the concept that the amount you use, the time you use, equals the fee you pay. So be very wary of arguments, well, the minimum period that we grant a license is 1 year, so you've got to pay that even though you've only used it for 1 week. And finally, a little clause which many people don't know in the IPLA is that actually they're only entitled to go back for 2 years. So if you've been using it for 3 years, you're actually under the IPLA, IBM's only entitled to 2 years worth of license fees. Again, buried away in the IPLA, but it's there. And that's quite important because I know people who have paid more than 2 years worth of license fees. And that acts as a contractual limitation. So I just thought I would just show you for WebSphere Application Server, obviously a very popular piece of middleware. You remember we were talking, and I'm just going to roll back to where it was. We can't find it now. Yes, this first question, can IBM change the terms of licenses unilaterally? And I said, no, you must agree to vary. So let's look at, this is the LIs over a period of time, which I've had access to see what they were many years ago. 2004, remember the change basically in the metric was in 2006 to moving on to effectively charge per processor core. Single install, single processor, and which one of those would be in the proof of entitlement? And processor equaled defined, actually used by program components. Fast forward to 2019 and see how very, very different the metric is. I'm not going to read that all out. Many of you will be familiar with that. But we've moved from installation, use, to actually availability. And indeed, in this case, we have one which is, if a metering tool is used, it's based upon the usage. If not, it's effectively, you're assumed to have used it effectively each month for the entire number of hours available. And this is based upon, of course, here, virtual PCs. We're talking about a virtual machine environment. So a very different licensing metric. And these are in the LIs. So the point I'm really simply saying here is that the reason that you may have moved on to 2019 metric as opposed to 2004 metric is that somewhere along the line, you've been upgrading, renewing your passport advantage, or doing some positive act, which in doing so means that you agree to vary effectively the licensing metrics. And that is worth bearing in mind, particularly because you may decide that the software you're using is perfectly good, perfectly stable, and there's no need to upgrade. And the cost of upgrading or whatever, if that means a substantial increase in your licensing fees, have a think, do I need to do this or do I not need to do it? So just a few sort of practical tips, which it's really important that you keep a very good track of licenses. Remember, a lot of licenses now are on the web. You're deemed to agree to the current terms and conditions as on the web. But remember, those web pages change over the years. You're not agreeing to whatever terms and conditions happen to be on the web now. You're agreeing to it as they were at that time. So if you're agreeing to it, make sure that you download a copy, freeze a copy of those licensing terms at that particular date. These are little tricks, not even tricks, just good risk management that you should do. Prior to renewing Passport Advantage, what are your current LI terms and conditions? If you renew, will you be accepting the latest LI terms and conditions? Very important, again, this is all part of good management. Make sure you understand what effectively renewals mean for your estate.
And for those who are unaware of where to find these proof of entitlements or license agreements, we do have some documentation and videos on that. So if you require that information after this webinar, just contact us and we'll send it on to you.
Thanks, Sherry. So a lot of people have asked me about a British case, which is probably one of the few cases. I'm sorry that this is a bit UK focused. Obviously, you can tell from my accent that I'm a British citizen. But a lot of people ask me about SAP and Diageo because this was really a classic software licensing case, software audit case, which actually went to court, which is very, very, very rare to do indeed. Sorry for the obscuring there by that knob of butter, but I'll tell you what it says in a minute. A lot of misunderstanding about this case, but the fundamental message from this case is licensing is not about economic realities. It's about the words of the license. So let's just sort of quickly run through how this one worked. This is my SAP software. People will be very familiar with that. There was a license based upon the number of named users. So Diageo had this very clever idea. Well, instead of basically getting their customers to phone up the call center to access my SAP, call center run by Diageo employees, why don't they give all their customers, and indeed some other persons, direct access to my SAP via third-party software, in this case, Connect and Gen 2 Salesforce. So if you understand how that works, instead of 4,000 people phoning up a call center and 10 employees basically interrogating my SAP software, those 4,000 customers are now themselves going to access my SAP. No change in usage, of course. It's just, of course, a change, but a substantial increase in the number of users. So what is underneath that little knob of butter is effectively, it's the same amount of butter being used, but it's obviously spread much more thinly over many, many people. Now, ironically, this was intended to be a cost-saving exercise because effectively it meant you didn't need so many call center employees. And it's very much in trend the 21st century. The 21st century is, get customers to help themselves. Anybody who's been into Sainsbury's or any other supermarket and find themselves being put to the self-help tills will understand exactly what I'm talking about. It's meant to save employees, allow for fewer employees and make your life, of course, more difficult. So what happened in this case was that the Connect and Gen 2 software, they used and accessed the My SAP software. And under the license, that effectively meant that a license fee was due and owing. Diageo's effective argument was, well, the level of usage hasn't increased. We've just got more people using it, but less often. But SAP were not impressed and actually brought an action, and SAP succeeded. because the customers and some of the other sales representatives who allowed direct access were not named users, and the licenses was on a named user basis. Thus, it was infringing use. And do notice that the judge found these are acts of infringement. It's not just a breach of contract. It's an infringing act to which damages for copyright infringement is to be determined. Now, in the SAP and Diageo trial, it was a trial on liability. It wasn't about how much was owing to SAP, but rather more whether or not Diageo had infringed the copyright of SAP. The judge found yes, and said that how much would be determined by reference to the nature and extent of usage. But SAP was seeking round about 64 million sterling pounds. I think it was then settled afterwards. I haven't been able to find anything to suggest what monies were paid, but I'll be very surprised. Now, interestingly here, of course, SAP is suing its own customer. A lot of people say you never sue your own customer, but it does happen. So what does Diageo tell you? Wording of license is king. It's not about economic realities. It can give an enormous windfall to the software owner. Be hyper aware of the terms and conditions. What is it? Ask vendor for all licensing documents. Often one of the problems I find is that people simply don't really know what are the totality of the licensing documents which govern their use, which really you shouldn't have to have a problem finding. Don't be afraid to ask what renewing support and maintenance, here passport advantage, means by way of change in license metrics and other T's and C's. If you do renew the S&M, demand that your licensing fees for your use will remain the same if the level of usage is not increased. Now, often you'll find that this is an impossible ask because you'll be told, well, that's not in our jurisdiction, that's not in our department. But do remember that audits often happen because the licensee is not caught up with the change in licensing terms. And they've assumed that because their level of usage has stayed the same, that they're not liable to pay further fees. I've given some fairly other tips, which I think you can see there. One of the things I do think, and I've said this earlier on, is do deep dive your licensing exposure. If necessary, get outside help. Try and be preventative. So many times we find in software audits that the problem has arisen because somebody hasn't truly investigated the effects of, for instance, as I said earlier, moving to a different physical environment, for instance, going onto a cloud, onto a cloud-based server. Try and make sure that every time the IT department puts forward a proposal, that at the same time, is that all right? Sorry, just mic just fallen off. Okay. Just make sure that when you do change, that just as much as you look at the effect in your IT, that you also look at the effect on your license fees. So quickly, how much time we got, Sinead?
Oh, we have another 13 minutes.
Okay. A lot of people ask me, is third-party maintenance of software lawful, whether it's for IBM or anybody else? And I try and use the analogy of a car. When I buy a car, I have a choice. I can either get the authorized dealer to maintain, repair, do an annual service, or I can get the network. And many people prefer dealers, authorized dealers. They like the comfort of working with an authorized dealer. Many people find that the independent network is actually more competitive in pricing, more hungry for your work. And you can have this discussion with many people and they will have many different views. But the short answer is nobody ever questions the right of, for instance, an independent garage, an independent servicer to service the car. And it's exactly the same in relation to software. There is perfectly lawful to have a third-party maintainer maintain software, even though the copyright does not belong to that independent servicer. But of course, it's got to be done in the right way. And that's important, and we'll have a look at how Rimini Street got that one wrong. But the fundamental rule, the take-home message here is third-party maintenance of software is as lawful as an independent garage maintaining and servicing a BMW car, for instance. So a lot of people say, well, what happened with Rimini Street? Well, Rimini Street, which is doing extremely well, but yes, they had quite a serious blip and a big run-in with Oracle. And what did they do wrong? Well, basically, Rimini Street did some things which they shouldn't have done. One of the ones was that they would, for instance, download software for one client and effectively, including fixes and upgrades, and effectively copy that over for other clients. That's not allowed, plainly not allowed. You can't effectively cross-license a patch from one customer to another. But interestingly enough, if you read the judgment, and it's a good judgment to read, it's by the first instance judgment is by a Nevadan judge from the state of Nevada. One of the licenses, the Oracle Novel license, did allow Novell to permit Rimini Street to install the licensed software for archival, backup, and disaster recovery purposes. So the judge had to look at each of the licenses, what is allowed, what isn't allowed. Again, we come back to this, what do the licenses allow, and what's the statutory overlay on that one? Rimini Street's doing extremely well. They got a lot of business. They bounced back because third-party maintenance is lawful. You just got to make sure you do it in the right way. You have to respect the software vendor's intellectual property rights, and that is critically important for any third-party maintainer. So just finally, before we may move on to some questions, often asked about patches, fixes, and upgrades. So any customer with a current IBM Passport Advantage agreement is entitled to any patch, fix, and upgrade, which is, for instance, on Fix Central. They can download them prior to the expiry date of that agreement. Not only can they download them, but they can then entitled to use those after they terminate, if they so wish to do so, their Passport Advantage agreement, and let's say move to a third-party maintainer. You've got to download them prior to the expiry date, but once you've done that, you can use those patches, fixes, and upgrades after you've moved to TPM. What you can't do, of course, is download patches, fixes, upgrades, basically made available after the expiry of the S&S agreement with the Passport Advantage agreement. That's something you're not allowed to do. But importantly, third-party maintainers can indeed provide their own workarounds to software, provided they write that software themselves. Finally, as I said, and I'll just go back to it, error correction in EU law is permitted. It's not an act of infringement. So I've said, but there is a sort of big health warning on this one. Arguably, you could use in EU law unlicensed patches, in other words, patches which you don't have a license to fix an error, for instance, a bug or something like that. But that's untested in law, so there's a bit of a health warning in there. But it certainly follows from the wording of the software directive. And with that, any questions?
Yes, we do definitely have a few. So I'll actually just kick off about something we've seen with our clients that is good knowledge for people. When it comes to IBM audits, the auditors are supplied with the documentation that IBM supply them. Sometimes they mightn't have the right license agreements. Do you find that too, Greg?
Yeah. So I tend not to get involved at the sort of audit level. I tend to get involved when, if I could put it, normally when a client is told by a software vendor that you're going to have to pay just $3 million, but $2 million will do fine. Thank you very much. But what I have found is that I'm given and I say, well, hold it, this licensing stuff is current. I'm looking at current terms and conditions. Where are the licensing terms which applied when you took out the IPLA? Sometimes they haven't. They normally have proof of entitlement. They often don't have license information. They've lost it, or it's, and so interestingly, Origina, of course, has got the license information going back for many, many years for each software product. So it's relatively easy to find, but it's not easy to find on the website. And so the date that you bought your IPLA, and I remember I use this word bought, you could say that's the wrong word, but when you buy a perpetual license, it's like buying a car. You're buying the right to use that software forever. If I buy a BMW, I don't say I license a BMW forever, I buy a BMW. But having the right documents, no lawyer can do anything with you if we cannot identify what are the relevant documents. And if you've upgraded, if you've renewed your Passport Advantage, you probably have unwittingly allowed yourself to creep into different metrics for your software.
And actually, this is something I just brought up. We do at Origina have all the license agreements that go back years. So it's in a proprietary system called OLAS, and it's our smart tool in our business. So if there is ever an issue and you're looking at switching to Origina, we do have all those license agreements available and at a click of a button. That you will not find on the IBM website.
Yeah, it's very difficult to find past LIs. There's no question about that.
So we have a good few questions. So one of the first questions is, can we leverage IBM entitlement to another geographical region using PPA?
That is a question I'm not sure I can answer because I'm not sure what PPA is. so somebody can tell me what PPA is.
Maybe they mean Passport Advantage using the tool.
Sorry, maybe that is clicked. I think I don't want to give a specific answer to that because fundamentally it will come down to your terms and conditions. It will come down to your Passport Advantage agreement. But if you mean by leverage, can you negotiate? Then that's a negotiation. I would have thought IBM will, generally speaking, as I understand it from certainly the documentation I've seen, generally very happy for you to move from one environment to the other. What's critically important, though, is what metric you pay. What are the fees for that? But IBM aren't there to stop you from using their software.
So this
is a great question. Thank you, Neil Edery, for that. Right to repair, is this based on where the action is carried out or the legal jurisdiction of contract or something else? And this is the sort of type of postgraduate academic thesis here. So I just want to try and help with that one. Generally, it's based upon the act where it's carried out. So if I have, to give you an example, at the moment in the United States, most tractors, John Deere, they've all got a lot of software on them. And as everybody will know, I used to have a Morris Marina, which had 3 moving parts, of which 2 generally didn't move. And I used to manage to be able to repair them quite easily. Nowadays, most cars, if the ashtray basically gets full up, you've got to basically take it into an authorized dealer because there's probably some sort of ashtray full button electronic measurement device. It's almost become impossible to repair a car. Well, software, but at least if I repair it in, for instance, Dublin, the right to repair law of Ireland will be the one which would apply. Software is a little bit more problematical. It's in the cloud. It's in this. If it's on a server, under your desk, it's going to be the law of the country where that server is based. If it's in the cloud, it becomes a lot more difficult, that question. So, for instance, if you're using Amazon AWS or if you're using, mainframes or anything which you're using, generally speaking, I would say it's where those servers are based. But I don't want you to think that I'm giving you definitive advice here. As for whether or not it's the contract, if English law applies, if under the terms and conditions, effectively, you can say, well, it also governs effectively what you're entitled to do, then it will be under the contract. But you may remember part of my slides was which law under the IPLA applies, and you remember that it was the place where the licensee is established. So you could have a situation, for instance, that the right to repair of EU law, which is, as I say, is much more generous than US law, under the IPLA, EU law will apply if the licensee is established in the EU. So some interesting parameters there. I can't give you a definitive answer, but it's a very good question.
The next question is, will the presentation be shared? Yes, after this webinar, we will share the recording of the webinar if you just want to forward it on to any colleagues you think would be of interest. And we will also include the presentation as well. So
Mark, of no surname, you've asked, please clarify the definition of willing in terms of willing licensor or licensee as per one of the slides. A willing licensor and a willing licensee, let's take it's not like a sort of Godfather mafia negotiation when the chap tells me, if you want to be a friend of mine, convince me. This is about two people going into an office, having a cappuccino and say, I want to license your software, and the chap says, and I want to license it to you. Have another cappuccino, have another coffee. Agreeing terms in a friendly environment, but both people want to reach a deal. So if somebody said to you, if a licensor said, well, I only license on 5 years or nothing, that wouldn't be a willing licensor, because if the person says, well, I only want to use it for 2 weeks, so that the other person saying is, I don't want your business unless you want to pay £5 million. So that wouldn't be a willing, that would be a sort of a bullying type of negotiation. It would be a negotiation which is very unequal, very one-sided. If two people want to do business, it tends to mean that the terms will be reasonable and fair. If one person doesn't want to do business but the other does, often the terms will be unfair and unreasonable. So in a way, willing licensor and willing licensee means that the terms and conditions, the licensing metrics, will be fair and reasonable on objective criteria. And when it comes to licenses, objective criteria will be things like the period of use, the amount of use, the level of use. All of those things are objective criteria. So willing, so basically it means two people having a cappuccino, having a friendly discussion in Starbucks.
Okay. So that brings us to the end of the questions, and we're just running over time. If you guys have any other queries, you can just email us after the webinar. And thank you all for attending, and thank you, Guy.
Well, thank you. I have to say, a great bunch of questions. At least it meant that some people were listening at some point during the seminar.
Yeah, no, we had quite a good turn up, so delighted. Thank you all. And
thank you very much.